The next panel discussion will address one of the biggest challenges facing the legal system: delays in cases and trials. The panelists will explore ways to ensure fair, prompt, and efficient access to justice while considering issues such as limited court resources, backlogs, shortages of staff, and time pressures. I'd like to welcome the panelists. Today, we have Ms. Edith Nordmann, Managing Partner and Attorney at Law at ACG International. Welcome, Edith. Next, we have Jain, International Arbitrator and Senior Partner at Regius Legal. Welcome, sir. And Rutvik Patel, Director and General Counsel at TBEA Energy, India. Mr. Rutvik, welcome. If you might want to do a little bit of a semicircle. Yeah. So you can click them upwards. Mr. Panelist, the last 10 minutes, Mr. Moderator. Who is the moderator here today?
That will be me.
Oh, there's no moderator. You're all moderators. So the timer will be set to 50, and the last 10 minutes will be for questions from the audience.
Oh, wonderful. There is
Okay.
a time management thing. That's amazing. Thank you so much. Well, I'm very honored to be here today together with these fine gentlemen. And it is a hot topic. Let me start with a short round of introduction. Please, Rutvik, I'll start with you.
Thanks. Thank you, Ish. Good morning, everyone, friends. I am Rutvik Patel. I am basically an Indian lawyer, and I work with Chinese MNC. That is the biggest FDI from India to China, TBEA Energy India. I'm a director and general counsel for this company. And I'm into this field for last almost 19 years. And I've practiced and then I've joined the corporate. So both the way I have tried to touch the work and scope. So this is the brief introduction I would like to mention here. Thank you.
Thank you very much, Rutvik. To you, Ish.
Good morning, everybody. My name is Jain. I'm practicing in the field of arbitration and litigation for now 15 years. Now I practice mainly as an arbitrator since the last 5-6 years. I've been empaneled with about 25 institutes in UK, Middle East, and in Asia. I'm also empaneled with the 4 high courts in India, and done quite a bit of arbitrations in technology, aviation, space law, and art law. So I will try to give my perspective from that jurisdiction, that field, and from the perspective of an arbitrator on the topic today. Thank you.
Thank you very much, Ish. Well, I think it would be nice if I introduce myself as well. Well, I'm Edith Nordmann. I'm the managing partner of ACG International in Amsterdam. I am a corporate and commercial lawyer and litigator. I've been doing that for more than 20 years now, originally from Switzerland. That's what I share with Vanya. And I'm also the chairman of the Netherlands-India Chamber of Commerce and Trade. I have a very international practice, and it's good to be here and to sharing thoughts also with you. I haven't shared that with the organization and none with my panelists. I intend to include you as well, because I want, it would be interesting to hear your opinion and your experience as well within this very interesting topic. So I will not wait to the last 10 minutes for Q&A, but I would like to include you, and I will do that regularly. To start with, let's say it's bifold, because one way or another, a non-speedy trial is nice for the lawyers. We have a lot of work and we like it. Lots of incidents and interesting things, raising incidents, going to arbitration, trying mediation, all these things keeps us going. And pumps our blood through our veins. We like that, but we also like happy clients. So there is a bit of a bifold thing here, but we definitely want to do our job right. So starting with you, where do you see the most problems in slowing down the process?
Okay. Generally, if since I'm part of a corporate, so and especially from the country India, where the laws are very complex and the litigation numbers are very high, and everyone knows about the speed of the judiciary. So the first thing is that we corporate generally do not appreciate the time the courts are taking. So number one. Number two, if we have the problems in the financial recovery, then we cannot wait for number of years that we get the solution from the court, because the Indian constitution is very clear, and not Indian constitution, it's the global jurisprudence: justice delayed is justice denied. So exactly the same situation is happening. We are working on the problems that we are right now exactly we are facing, that why we are getting delayed. So when we see the laws, that the problems are with legislature, problems are with judiciary, executives. Where is the problem? When we see the Indian laws, fine. For example, we say we take example of Negotiable Instrument Act. So there is a provision that it has to be finished in 6 months' time. If we see even Civil Procedure Code, which is the oldest, even was incorporated or constituted prior to the independence of the country, it also has a specific clause in which the courts will have to give the justification why they are granting the dates further. So the laws are clear, legislature is very clear. Then where is the delay? Why this problem? Then obviously the matter goes to the judiciary. Without any intention, I would like to mention that if we see the role of judiciary, and when suppose if there is a foreign direct investment like we have in India, or any corporate or any other person, if he's coming and want to face the litigation, then it will become a very difficult for the person. So how to resolve the issue is a question.
That's for the next round.
And that is the issue, that when we are facing that, when we have recovery of crores, what are the alternatives? How we are going to take up? So these are the basic issues. And when we see that judiciary, and when we compare the judiciary and legislature, then obviously we find there is a lacuna and problem in judicial decisions. That's why there is a clear slowness and delay in the proceedings.
Okay, thank you very much. Before I turn to Ish, who thinks, sitting here, that the problem in delay, well, we're all lawyers, is with the judiciary? Hands up, please. Yes, thank you. Sir, you ask a lot of questions, which is fine. So why do you think it's with the judiciary? Yes, please join in.
Good morning. Sorry, is that working? Yeah.
Good morning.
Good morning again. Thank you very much. You know, I've been an ex-judge, so I know it from heart. I know it from the kitchen more than anybody else, maybe. So sometimes there is a problem actually with the load the judges are having. And there is no, sometimes pre-analyzation, pre-preparation for the documents, for the hearings, that's coming to the judges. So they'll be overloaded, and sometimes managing the cases will be a problematic for judges. So they have some sort of partial involvement. Sometimes it's the system itself actually that imposes more difficulties actually on the judges on dealing with cases. So it's judges sometimes, if they don't know how to manage the cases very efficiently, that actually will impose more hurdle in terms of managing the time in resolving the cases that being heard before those judges. But it will not be one reason. Actually, it's a mix of reasons. And if there is a time, we'll talk about that a lot. But actually, and I can tell about it from experience, especially from in-house, you know, being an ex-judge. So especially Yani the core thing is the support functions for the judiciary system is also play a significant actually role in whether reducing or increasing the pressure and the load and the time. Thank you.
Thank you very much. I'll come with an interesting suggestion in the next round, but first to Ish. Where do you see the problem?
Well, I see a lot of problems. But
That's what we do.
yes. So one of the, in fact, in the first few years, I was fortunate that I practiced with an arbitrator, and before I actually, jumped into the hardcore litigation, I actually was with an arbitrator for 5 years as his research assistant, and I could upfront see when I entered litigation of the difference between arbitration and litigation. And as our topic today is, that the problem lies at the trial. So leaving aside the problems of conflict of laws when we go to the international disputes, leaving aside the quality of judges or the outcome of the cases, I mean, leaving all that aside, the primary delay that is caused in our litigation system is at the stage of trial. And I think the first problem that my experience has led me to believe is the limited amount of judges that are there in most of the jurisdictions that I've practiced in. And for example, in India, we have about vacancy for 471 judges only in the high courts. So I mean, this is a kind of vacancy which cannot even be filled in the next 5 years. I mean, you can't overnight have about 471 judges added to the bench. The second problem is the limited amount of working hours for the judges, the time schedule for the judges. I think they're just constrained with so much of work, and with all due respect to one of the ex-judges that we have, I mean, he would testify to the fact that they're burdened with a lot of work, and for them to be able to schedule in a particular day of how to bifurcate trials from emergency hearings or matters which require urgent hearings, it becomes absolutely impossible. So this is something that we need to try and resolve for the judges, and the judiciary, the judicial management needs to support the judges. The legislature needs to support the judges to do that. Another problem so these are the first two problems that primarily are common across all jurisdictions. Then we have the problem of the predominant nature of the lawyers. Like, I mean, how many times have we faced a situation where either we have to seek an adjournment or the other side seeks an adjournment because the arguing counsel is not there or the cross-examiner is not there. I mean, it's a part of our practice, and there is no way out of that. But as lawyers, we are also a part of the problem, and we need to find a way to resolve that. But yeah, that's about the two problems. The third problem is the lack of practice of having cross-examinations on consecutive days. How many of the courts do we see allow cross-examinations to run on consecutive days? It's hardly happening, across multiple jurisdictions. I mean, except for a few developed countries, everywhere else I have seen that the cross-examinations don't happen on consecutive days. We have judges who give dates after a month. I mean, as a trial lawyer, you need to then start preparing for that witness all over again. That just consumes more time. That's one of the reasons why the lawyers are then forced to take adjournments, because they're not able to schedule it in a particular manner. So I think that's the fourth problem. And the fifth problem is complicated laws and procedure, as Rutvik just mentioned. I mean, it's just so complicated that there is no room open for the judges to expedite it. If a procedure provides that a next thing has to be done, and if the judge doesn't follow it, the first thing that a party would do is appeal it. And that's where the stay starts. So you go to the appeal court, and the appeal court then stays the proceeding until the appeal is not decided. We are at standstill in trial. Again, a major cause for the delay. So I think these are the problems that I think needs to be addressed. And yeah, I mean, it's something very easy to talk about, but very difficult to resolve
Absolutely.
overnight.
Let me tell you something shocking, ladies and gentlemen. Our judiciary in the Netherlands, they also lack a lot of people in workforce. So they came up with an interesting idea. And not only was it an interesting idea, they put it into law. And the thing is, I haven't told you that, they reduced the brief, the appeal brief for the lawyers to 25 pages. 25 pages for an appeal brief. Can you imagine? All cases, 25 pages maximum in appeal. Why? Because the appeal judges, and the bench is always containing out of 3 judges in the appeal, they got briefs, well, we know them because we make them, of hundreds of pages, which slowed down the process. So they came up with an idea and decided to make it a law to reduce it to 25 pages. Of course, the lawyers went to court to fight it, and they lost. They went up to the appeal court to ask whether this was legal, whether this was good practice and in the interest of the parties, and the Supreme Court agreed that the courts can do that. So now we have to put our appeal brief into 25 pages without attachments. You know what happens, right? We put everything into the attachments. But still, you have to think a lot. And the idea was, if you can't put it within 25 pages, you have to rethink. And if there are more than 25 pages, what's going to happen is the brief will be sent back, and you get 2 weeks to put it into 25 pages. If not, then they will cut it at 25. So whether this will help to speed up the process in the appeal procedure, we will find out, because this has been introduced lately, last year actually, and we'll see about that. So that's, at least from the judiciary's part in the Netherlands, one of the tools to speed up the process themselves. I have some other interesting news from the Netherlands, but before we get to that, Rutvik, you have experience in China as well as in India. Could you share the difference in approach, how to solve the way of speeding up the process? Would be interesting.
Yeah, definitely, Edith. If we compare both the jurisdiction, Indian and Chinese, let's not talk about, I'm not talking about the fairness of the trial, I'm talking about the expeditious trial. So in India, there is a concept that even if 10 guilty people are set free, one innocent should not be pleaded guilty. So that is a different concept. And that's why the Indian jurisdiction is, the courts are, judiciary is taking little cautious action to go ahead for any trial. But if we see in the Chinese jurisdiction, they have already implemented plea bargaining. So this is one of the fastest way, but plea bargaining, I would say that India also has started for, since I'm from the state of Gujarat. So the state of Gujarat has banned on the liquor is not allowed. So this is called prohibition cases. So such small cases, we have a plea bargaining, but we don't have the concept overall. And I think both of you would agree with that. In Chinese jurisdiction, this one is for the criminal and civil also. And for money matter or civil suits, they have a very beautiful established system that the courts are considering the rights of the litigants also. And they feel that after going through the documents, they also try to set the talks between the parties, and if try to like mediate, they try to mediate also, and they try to order. If the mediation fails, then straight away they order, so that the matter goes fast. So all the trial that, like if we go in Indian Civil Procedure Code or other codes, all the trial in between is eliminated. It straight goes for the evidence, and then it moves further for the judgment. So basically, mostly it goes on the evidentiary value. So this is how the Chinese jurisdiction, the Chinese Supreme Court have taken one step further to expedite, to deliver the justice on time.
Is it for small claims or also for bigger claims?
For punishment up to 3 years, they go for the plea bargaining.
That's the criminal case.
Criminal
What about
cases,
the
criminal
commercial
cases.
ones? Is there a plea bargaining thing in a commercial case as well?
That's also there. So they try to go for its plea. Plea is mainly for the criminal thing, but for civil matter, there's the same procedure that they discuss with the parties. They come up with the judgment based on the evidences and the documents. So generally, it is 6 months or 1 year. They try to finish up the matters.
Okay, first instance, right?
Yeah.
Well, in the Netherlands, this is standard 1 year.
So
For a basic procedure, but we'll come to that. But that's quite quick. So in India, if you compare it to that, going to Ish, how long would such a procedure take?
Well, for a civil proceeding, it would for even small claims. So obviously, we have the introduction of the commercial courts in India, and having the whole enactment in place. The problem is that even if the enactment is in place, the implementation is near impossible, because with several high courts in India, almost each state having its own high court. These are the courts which are deciding on the commercial disputes in an expedited manner. We still have the limitation that the plaint and the written statement has to be done in XYZ days. It says that the witnesses are to be examined on consecutive days, but it still does not put a restriction on what is the consequence if the witness is not examined on consecutive days. What is the time limit within which a trial is to be completed? It does not put a limitation. For example, as you mentioned, that the appeal courts in Netherlands have restricted it to 25 pages. In India, we have claims which, for hardly a few $1,000s, you will have plaints which will run into about 60-70 pages, and it's utter nonsense. I mean, you don't require 60-70 pages to justify a small claim, but the judge's hands are all restricted, even in commercial courts, and it's difficult to reject it. So even if you have laws in place like the Commercial Courts Act in India, it's becoming near impossible to implement it with the diversity of the judges, the cultural background that's there with the judges. So these are the judges who were lawyers in a different generation in India, and the younger generation has really not come up as yet to be those judges. So it's probably a few years before we actually see what Rutvik is saying, that we'll have that implementation of the Commercial Courts Act in India. I mean, it's going to be a long process.
Well, thank you very much, and also for the keyword commercial court, because once again I have a surprise for you, but this one a nice one. The Netherlands has started with the Netherlands Commercial Court in January 2019. It is for international commercial matters that have not necessarily something to do with the Dutch court or anything. It is a chamber of the Dutch court consisting of 3 judges with experience in international matters. It has to do with international commercial disputes. And it is quick, easy, and fully in English. So actually a solution for speedy trial and the best of 2 worlds between arbitration and going to the normal court. And that's an interesting thing also because of the costs. We haven't been talking about costs yet, because one of the things that court has also done is to have a flat rate, flat fee, 10,000 euro per party. That's it. Whether you come for 100 million, 1 million, or 100,000 euros. because in arbitration, I don't have to tell you that it's extremely expensive.
Touching my bread and butter now.
Yeah, I thought so. But also, together with the president of the Appeal Netherlands Commercial Court, I had the honor to be invited to come to Milan to join with the judges of the Paris Commercial Court and the Stuttgart Commercial Court to talk about with the judiciary and the lawyers of how a commercial court in Milan should look like and what the experience is in Amsterdam. Let me tell you that, of course, the Amsterdam Commercial Court, the Netherlands Commercial Court, was of the European courts the only one that has a fully English process from all the briefs through the hearing itself to the judgment, including the judgment and the appeal, which means that not only you can go to the Netherlands Commercial Court and use whatever law, material law you would like to apply, you choose it and they apply it. But also the foreign lawyers can be active within this procedure, which makes it very, very interesting. And which also was the reason why the Milan judiciary and lawyers invited the Netherlands Commercial Court to talk about it. So, talking about speedy process, summary proceedings with the Netherlands Commercial Court, and I'll come back to you, and I would like to ask the ladies and gentlemen here in the audience as well. Summary proceedings at the Netherlands Commercial Courts. Within a few days, you will have a judgment. And it will be fully in English and fully enforceable. So think about it. Next time you need something quick, which isn't that expensive and not going into arbitration. So who of you is using arbitration instead of going to the judges to speed up the trial? Yes? Is it only about speed or other arguments? Yes, please.
Wait, I'm bringing the microphone to you, sir.
I think you should leave the mic with him now.
Yeah, okay, thank you very much.
You should keep it for the day, yes.
Yeah. So, I like such interactive sessions actually, and this is very, very, close to my heart topic. So there are so many reasons actually in terms of complexity of the, the dispute, nature of the dispute. Okay, especially when it comes to specific types of disputes which we cannot take to court, where you need to have subject matter experts actually who can really understand what the case is about, and what sort of debate that the parties can have. So, and also it's related to the value of the dispute. So we don't go to arbitration if it's small value type of dispute. So this is key for us. So it's about the nature, the complexity of the and subject matter experience that's related to the disputes mainly. Thank you.
So is there a special arbitral court that you go to normally?
Yeah, it's as arbitration centers. It depends actually where the parties are and the selection of the parties in the contract, whether that's regional or international. Mainly, we go sometimes to Dubai International Arbitration Center here in Dubai. Recently, because I'm coming from KSA, the arbitration, is still young, actually. They're still developing, but we are witnessing big change, big shift in, the arbitration center in Saudi Arabia. For sure, the normal international, well-known like LCIA, ICC, will be always one of our main targets in terms of selection.
Would be interesting, by the way, because we also made a comparison between, there is a commercial court here in Dubai as well, and there is one in Qatar. So, but they are also, their court fees are immense. And regarding the qualification of the international dispute, it is a bit more narrow than what we have in Amsterdam. But I'm happy to share it with you. But
sure.
We'll come to
Looking
you back
forward.
again.
Looking forward.
Sorry, but, just to continue where my friend has left off. I agree with him because there are, for example, I deal with specific disputes in aviation law. And obviously, Netherlands is not a problem with aviation law and space law. We have the entire of the Leiden University and just the establishment of the Hague Civil Aviation's Arbitration Center. So, Netherlands may be a one exception, but, overall, we don't have specialist courts which can deal with disputes relating to technology because of, sometimes we have judges who are not aware of technical aspects, or especially relating to aviation and space law, or for that matter, art law. I'm sure Vanya can testify to that fact that, a lot of times we have art law disputes where the judges have no semblance of idea of how an art law dispute has to be perceived, because it's very subjective. Art is very subjective, and the laws revolving around that are not so developed as yet. It's a lot of drawing inference from the contract law. So, for those kind of specialist disputes, you would still require, parties to go to arbitration. And obviously, just to add on to that, we also have the confidentiality issues in these kind of disputes, because, these are sensitive data, and you wouldn't even want the awards to be released at some times.
Absolutely.
Yeah.
Confidentiality is
Yes.
a big thing, and
Yes.
that's also one of the reasons why people would go to arbitration. We can ask for closed doors hearings, but still publication. We can also ask to put it in a way in which the parties are not visible, but like with privacy, if you put one and one together, you know where you're at.
But that's the difficulty. So even if you have somehow prevented the publication of either the award or the court judgment, when that kind of provision is there, the question comes of how do you then enforce it? Because for enforcement you need to go public, and that's the conundrum that we are there in today. And a lot of technology companies, and especially in space law, because again a lot of space law disputes are having a small aspect of national security also involved, because we have the state which is backing up those companies, and that kind of involvement normally triggers the whole, how do we maintain the confidentiality at the same time seek the enforcement? So yeah.
Well, combining art and enforceability, there was a very interesting judgment in the Netherlands recently about NFT. It was in February of this year. Well, not that recent anymore. But what happened was that there was a gentleman who wanted to buy a piece of crypto art, of an NFT, with a bet on it, a crypto bet. And that was made by a famous person in the Netherlands, at least. Well, Ozzy Osbourne was the name. And there was this bet on the NFT, and then you have all these little particles, and the bet had a part, and then there were some blue parts around it. So he asked somebody to buy it for him. So when the guy bought it, he found out that this was a very rare piece of the puzzle with a very interesting part of the bet. So he thought, well, you know what? I'll keep it to myself, and I'll buy a new one and give that to the client. But the new one that he bought was just a piece of blue. So the gentleman who asked the trader to buy the NFT found out very quickly, and then he said, that's not okay. I want my piece of NFT with the bet on it, because that's what you bought for me. So they went to court, and the court ruled, and they could enforce, that liens were put on the NFT. Liens, can you imagine? So they put liens on the NFT, plus the obligation to give the right NFT puzzle piece to the gentleman. So that was quite interesting, because it combines enforceability as well as giving it to it. But one more thing. No publication of the judgment. We know that it's there, but they didn't publish it. So that's very interesting. Rutvik, what else do you think is interesting in the solution of speeding up the trial? Commercial courts against arbitration, mediation, going to normal courts. What are your thoughts to solutions?
When we talk about the trials, mediation, arbitrations, definitely even as I mentioned that the laws are clear. Like even for the summary, we have a civil procedure code. There, for any commercial matter, we can also ask the court, and court has to deliver it within the shortest span. Even still, it is taking the longer time. So here, generally, by instead of going to the trial, so the best option is to go for the first for the mediation. So why mediation? Because if you see any dispute, so dispute starts, I would say, with the psychological aspect, that's ego. So let's try to resolve this. If things cannot be worked out, then definitely it will go further for the arbitration. And now the India has started developing the arbitration laws in a such a way that it has to be finished in maximum 1 year's time, and after further extension, it has to be not more than 6 months. So again, arbitration is fantastic remedy instead of going for the trial. But before going for arbitration, I would at least prefer that my company should not go into unwarranted cost, because arbitration is not so easy way in terms of cost. So I would prefer that why can't I discuss directly? First, try to let's have the settlement talks with the parties. If not, then I should take the support of somebody else who can come and mediate, so that mediator will at least try to support us, and both the parties, they will try to get he will try to get convinced. And if things go well, there's a number that almost 35% to 40% disputes can be resolved if the mediation is put in a proper way. So this is one aspect. And if things cannot be resolved, then the third aspect is the arbitration. But again, arbitration, if we agree into the arbitration, that there are the people agree nowadays that okay, I am a company and other party supplier, for example, is a small party. So I will say I will appoint my person as an arbitrator, which again the Supreme Court of India has said that no, this is not a fair trial. So again, we have to approach to the High Court or the Supreme Court, as the case may be. This is I would say it's a faster remedy, but faster remedy when? From the date the High Court or Supreme Court appoints an arbitrator. So before that, again, you have to come into the judicial proceedings. So try to resolve. My best solution is try to resolve by way of mediation. So it can be avoided. For criminal matter also, uh, India does not have we do not have the plea bargain, but at least for some of the penalties, at least for 3 years and all, for this matter it can be resolved. And as you said about the commercial court, it was a fantastic example. The courts have now started adopting the commercial courts approach, and there is a law now about the commercial court. It has to be finished, but again and again it is again going for the same way of the civil procedure code. So the real intention of the framers, it has got diluted. So that's why before going all into all the issues, I'm so sorry, you are all the people are lawyers, but I would say I will just give you example that somebody asked me that why are you insisting for the mediation. I would say that plaintiff who is fighting for the head of the cow, defendant who is fighting for the tail of the cow, and the lawyers, including me, we fraternity, we keep on milking the cow. So any organization would not, sorry for this, any organization would not require this kind of cost. So mediation, I would prefer that with this way, at least the settlement can be quicker and we can get the results immediately. That is my point here.
Edith, with your permission, my 2 cents on what Rutvik just said. Insofar as Rutvik, you mentioned about mediation, I completely agree with you. I mean, that's if you have the choice, you should mediate first. But it can't be a compulsory process of. So, for example, because of what you said is correct, and because of that thought process, I think in India, especially, you would see that they've tried to overreach the mediation aspect, where they've made mediation compulsory in commercial courts disputes. So what you are doing is on one hand expediting the process by saying, we will have commercial courts. But on the other hand, you're saying that, oh, you have to mandatorily go for mediation before I take the case on file. And practically, if you see, you are now delayed by 6 months because your mediation goes on for 6 months. So you've just taken 2 steps forward and 1 step backward. And mediation should be a voluntary process because, and I'm sure you must have experienced this, that when one party goes to the mediator and says that I want to mediate the dispute, and the respondent says, oh well, this is going to be now fun for me, and let's try to delay the process. And he says, yes, I'm interested in settling. But at the end of the day, during the mediation process, there is zero inclination from the respondents to actually try to settle the dispute. And that simply causes the delay. So I feel that, the idea of mediation is fantastic, but it has to be a voluntary process from both ends. And both should have the same mindset that what you just suggested. That is so far as the mediation goes.
Well, let me add to that. Of course, in the Netherlands, we have a solution to that as well.
Well, Netherlands has all the solutions.
Yeah, you should all come to the Netherlands. Because to add to the mediation part, in labor law cases, a judge will not adjudicate your process if you haven't tried mediation first. So all the parties know it, and from the employer's end, they usually say, okay, we have to go into mediation, but actually we don't want to, right? So what they organized in the Netherlands, also from the mediators themselves, is a pressure cooker mediation in 1 day, which is accepted by the courts. The lawyers, together with the parties, go and sit at the mediators' table for just 1 day. You sit there and you decide upfront that if you cannot reach an agreement within 1 day, you go back to court. So it will not take you 6 months. And it is, why are the lawyers there? Because usually they are a disturbing factor, as we all know. In this particular case, the idea of taking the lawyers to the mediators' table is that the parties, when they reach an agreement, the lawyers at the table of the mediator can write the settlement agreement there and then. Because we all know that if the parties go to the mediator, they go back to either their spouse, which is also a problem, or their lawyers, and they tell them, yeah, we've reached a settlement, even if it is not allowed to talk about what they did in mediation, they still do. And then the partner, the spouse, or the lawyer says, are you crazy? You should never have accepted that. You go back and you renegotiate. That's what's happening, right? So that's why we do a 1-day mediation in which the parties are there until they are so tired that they want to settle at the end of the day, and they will. And then the lawyers draft the settlement agreement, then there you are. So that's how we solve the problems.
That's excellent, actually.
It's nice, right?
Yeah, excellent.
That's really nice. And as Ish said about, yes, 6 months delay, I have also seen this kind of practical issues. But when we see mediator, by virtue of Commercial Courts Act, a mediator is appointed. So that mediator is generally picked up from the local bar. He is unfortunately not aware what are the issues. Technically, he is not so sound. So if a judge feels, or if a mediation center feels, oh, I'm having good relations with this gentleman, he can be appointed. So this is a negative point. So if we put this negative point apart, and if we really feel that for example, I feel that Edith is the best for solving this issue, if I come back to you and you will support us, to me and Ish, to solve the issues, definitely why can't we solve the way you have solved just now? So
I think the solution that Edith is suggesting is that you should have that 1-day mediation, and that's like the excellent solution. The only difficulty, Edith, and this is where we'll require Netherlands help, for especially jurisdictions in Asia, obviously barring Singapore completely from that common analogy. How do you have trained mediators? Because as Rutvik correctly mentioned, the problem of mediation, even if you have a 1-day mediation, is we have retired judges who are acting as mediators, or practicing lawyers who are acting as mediators, and we don't have professional mediators mediating the dispute. And the problem is, once you have a lawyer or a retired judge, the perspective of mediating a dispute is lost at some point, I feel.
Interesting. Anyone in the room from Germany? No? Well, let me tell you that in Germany, I think one of the problems as well with mediation is that we as litigators, we think that mediation is a soft thing, right? 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 You know, hardcore is going to court and soft skills is doing mediation. Well, in Germany, they are cleverer than we are because they think that mediation is a very important thing also in commercial matters. And they take this very seriously and they're doing a great job there. So any comments from the room, from you? About mediation or arbitration? Yes, sir.
Hello. Yeah. Hi. Good morning. My question about mediation: how it could solve such problem with major companies, just like what happened with let's say FTX and other companies who deal with a lot of consumers inside one platform. So such thing, mediation could not work there because you will not settle with, let's say, 1 million customers. What do you think the mediation on such cases, or it's not possible?
I'm trying to see whether I understood your question correctly. How to solve consumer matters in mediation, was that it?
Yes, especially with the big platforms, such you have 100 or 100,000 customer. How you will mediate between the two parties, because the second party is 100,000 customers. So who will be representing them?
Yeah, there are some organizations, or at least I'm looking at my colleagues here. There in the Netherlands, we have some organizations who are taking care of these consumers and also organize these kind of alternative dispute resolution, let's put it that way, because there are various possibilities of doing that. And I don't know how it is in your countries, but consumer protection in normal legal proceedings is huge and is a huge problem for companies actually and businesses, because the consumer protection is so high that they don't even have to go to mediation because they already have an advantage when going to court by just being a consumer. One of the things, for example, is in unfair trade practice. If you get to the bar of unfair trade practice, that's what lawyers do in consumer rights, then the company has to prove that they're innocent instead of the other way around. So that's one of the instruments that the law gives the consumers in the Netherlands. And I'm quite sure that it's like that in other countries as well.
Well, many jurisdictions, including India, have their own consumer courts. So, I mean, consumer disputes are actually taken out from the civil proceedings, from the civil courts, and they've been given separate judges and separate adjudication process to decide those disputes. And unfortunately, this has happened prior to arbitration kicking off in most of these countries. So the arbitration and mediation has so far not had a chance to interact with the consumer court, and there has not been an overlap where, I mean, to be honest, how many of the companies, when they're transacting with their consumers, would put an arbitration clause? I don't think anybody would choose that, because
it would not be allowed in the Netherlands. It is it's against the law.
Correct, and so therefore, to have arbitration or mediation conflict with the consumers is something that we will not see for some time, or will be an exceptional case. But if I've understood, what you try to ask is what happens when a company faces. And this is apart from the consumers. What happens when a company faces, for example, we have in the maritime law. I mean, it's not the consumers per se. It's the whole different client and client kind of based and contract based, where you have multiple LCs and different forms that you have to comply with and different submissions. So, for example, if you have Maersk, they have about on a daily basis, even within India, they have about 5,000 contracts which they enter into on daily basis, and none of them would qualify as consumers. So how does Maersk deal with this kind of dispute, where can they mediate with 5,000 of their clients or 5,000 contracts? Isn't that what you're trying to ask? So, well, you will have to, logistically as a company figure out of having, in-house teams which are trained in mediation to deal with these kind of disputes and have your own, redressal mechanism within the company for addressing those clients and trying to hold a mediation so that the client does not drag you to the courts or to arbitrations, which is an expensive process.
interesting.
And
Yes,
I'm sure Rutvik can tell us more because he comes from the company
Exactly.
which would be faced
Yeah.
with this kind of problem.
So I agree with both of you, but two things we need to consider very clearly. The consumer rights, as a general principle, these are all statutory rights. Globally, global jurisprudence is giving you as a consumer statutory rights, while all your arbitration or mediation, these are your contractual rights. So even if you have a contractual rights for the statutory rights specifically for consumer or for small suppliers, there is no restriction. Even if you have a contractual right, still your consumer can invoke its remedy under the statute. So that is a very clear fundamental. But as Ish and they clearly mentioned how to resolve this kind of issue, then your contracts, you need to identify which are the contracts. The contract has to be well defined about the mechanism or settlement procedure, and if it cannot be settled, that what are the alternative dispute methodology that you need to move further. But if still the matter goes to the consumer, so for example, the person takes you to the consumer redressal forum, and there if the representative goes and asks for the settlement, even then the tribunal itself will support you. In India, we have this kind of system that tribunal will support you, that okay, you come and negotiate and you settle the matter. So tribunal here will act as your mediator. So that is the difference.
Also, these are the kind of issues that are faced by financial institutions and banks which are lending, where a lot of them are lending to their clients, and those will not fall under consumer because they have their own debt recovery laws and the banking regulations which will govern them. I think one of the aspects that I have seen in my arbitration practice is most of these financial institutions and banks have a mechanism in their dispute resolution where they say that a particular designated person from the financial institution or bank would first try to mediate this dispute within the first 30 days, and that's where they try to avoid going to the arbitration or going to the courts or any debt recovery mechanism, and try to resolve and see if the recovery process can happen in that first 30 days. So I think that's one of the solutions, that you have your own redressal mechanism where you have trained mediators or in-house counsels who try to resolve this dispute, keeping the interest of the company as well as of your client in mind.
Yeah, that's a very good solution. By the way, one more thing with regards to consumer law. Once you have you claim that it is an unfair trade practice as a consumer, the other thing that the consumer will ask, and which will be automatically granted once the judge will assume that it is an unfair trade practice, is the annulment of the contract. And it will be granted. As soon as the judge thinks that it's unfair trade practice, for example, putting in a clause where people have to pay crazy penalties or have to go to arbitration or something like that, then the judge will say, okay, unfair trade practice towards a consumer, and the annulment claim is assumed. So then you don't have a contract anymore and the company has to pay back the money. And that's also a very strong instrument within the Dutch law, stemming from European rules, of course, to make sure that the companies are not putting things into their contracts which are harming the consumer. But one last round of words of piece of advice you already gave yours, which is amazing, but still I will give you the opportunity once more. Please, what is your piece of advice regarding slowing down speeding up the process and slowing down problems in the meantime? And maybe also in comparison to the way that China is solving that, would be interesting.
in simple language, a piece of advice would be: first, initiative by lawyers. That is the first and foremost thing. Secondly, you need to push the judge to move forward. And before moving further, at any juncture, if we find that dispute resolution is possible by way of mediation, it is a fantastic remedy to resolve, because no institution can afford to continue the litigation for the years. As a lawyer of corporate, I feel that my company is bleeding. Even with a single day, the judge or the court is taking time. So every day I have to pay interest to the bank institutions, which is not acceptable to me. So even if I can consider that what is the best solution I should adopt by way of mediation at any juncture, I should create much pressure on my lawyers to move faster in the court, and simultaneously, with the help of both the parties, we can jointly represent to the judge also that, sir, please expedite. These are the problems. So these are the simple advice that we can expedite, or we can speed up the trial.
Thank you
And
very much.
solution, not the trial. We can
Yes.
get the solution at the end of the day.
Perfect. Thank you very
Thank
much.
you, Edith.
Ish, your closing words.
Well, my closing words are very simple. Have more judges, enable them to devote more time to trials, and curtail the practice of seeking adjournments because of lack of counsel, or because of lack of availability of parties, or just make the whole disclosure process more simpler. Until that happens, I think the fastest remedy still lies with arbitration. So unless the courts find a way to get over these lacunas, and the parliament enables appointments of more judges in these multiple jurisdictions, especially places like Brazil, India, and China, where the population is enormous. So you require equal amount of judges in those jurisdictions, and until those happen, the parties will be forced to seek for people to adjudicate the disputes outside the courts. And that's my 2 cents on
Thank
the
you very
solution.
much. Okay. Some final words from my end. We are called advocates, which means we are advocating for our clients, right? That's what we're supposed to do. So my closing remarks would be, in advocating for our clients, we have to think of the best strategy in the interest of our clients, because sometimes we kind of get caught up in the game because that's what we like. And maybe once in a while, before starting, we should think of the strategy which serves our clients best. And sometimes it's not in court, but outside, even if we like to be there. And even when in court, we can still, adapt the strategy if we see that things are not going on. And sometimes, settling can also be better for the parties than going on. And let's be honest, a happy client is a joy forever. If you do that, they will stay with you, and there will be more nice cases with them. So that would be my advice. Think of what your client needs and give it to them. Thank you very much. Also to my panelists.
Thank you, Edith. Thank you, Rutvik.
Thank you very much.
Thank you. Ish.
Any
Thank you
last
very much.
questions for the panel? Challenges you are facing?
We already did that.
My name is Aya. I'm from Egypt. I'm a partner in a solid law firm. Well, in Egypt, we have either one of 2 ways. Either it's litigation, which, as you said, takes a lot of time, or arbitration, which costs a lot. So when I come to something applicable, it would be mediation. But there is one problem, that even if I draft a contract, I don't know on what criteria to assign a mediator. Is it best to be an expert in the business field, or just a lawyer or a judge, retired judge, who has a legal background? So I'd like to know your recommendation if I'm going to assign or choose a mediator, in order, because this will be more applicable and more, easier and faster for my client in Egypt. Thank you.
Okay, interesting question. Thank you very much. Well, what we do actually, and I'll ask the gentleman in a second as well, is we have lists of trained mediators, registered mediators who had taken tests and exams and all these kind of things. They come from different backgrounds. Some of them are lawyers, some of them have a psychology background or something like that. In the registry that we have, it says what the background of the lawyer is. So mediation should be willingly from both parties, different from what we do. We just go for our client and that's it. And what we do is that we have the parties choose a mediator from the registry. And if they cannot choose one amongst them, we usually have a list of 3, 4, 5 mediators who would be best for the case. And then the first task for the parties is to come to an agreement on who the mediator is going to be. But it's going to be somebody who has exams and who is in the registry. That way they can choose somebody, for example, if it's a commercial case, somebody with commercial a background, or if it is an international case, somebody who also speaks various languages. Or if it is something more family law-minded, then you can have somebody, there is a special group of mediators for that. Any additions from
I think the solution to your problem would be, first, as Edith mentioned, you need to be sure that you pick a mediator who's trained, and that's where most jurisdictions are lacking of trained mediators. We have list of mediators in a lot of developing countries where, as I mentioned earlier, we have lawyers who have not been trained, we have retired judges who have not been trained as mediators. So you need to pick, and I'm sure, and obviously from my experience, I feel that Egypt is one of the jurisdictions where this is still predominant, where there are lawyers and retired judges who are still acting as mediators when, and I'm not saying that they can't act as mediators. It's just that they're lacking the attitude and the training of what is to be achieved in mediation. It's to be settled. The idea is to settle. It's not to ask one party that, okay, this is what you want and this is what you want, and we have A and Z, and just try to pull them somewhere between N and O. It's not something of that kind. You need to sit with each party and make them realize as to where they stand and what is more reasonable and practical for them to achieve out of the litigation if they pursue this course ahead. And the second solution would be, to time bound your mediation. Unfortunately, a lot of these jurisdictions have a problem that the mediation goes on for months. And, as Netherlands has a practice of having the mediation in one day, probably for some of the companies, it will be a near impossible task to do. But you need to get closer to that 1 day target, probably have 7 days or have consecutive meetings. Because moment there is a gap in the negotiation, parties lose interest in mediating the dispute. So, you need to have meetings consecutively because the pressure is built and the parties constantly see that, we are heading in a particular direction. And the third is, if you see that the other party is not responding to mediation and this is just a delay tactic, terminate the mediation and move to the next step immediately, because, you're just wasting time in the hopes that the other party is genuinely going to mediate the dispute. You having an intention to mediate is one thing. Your respondent or your claimant, asking for mediation is a completely different aspect.
Thank you. We have another question from the gentleman going to the center microphone.
I'll just mention one point.
Go
Sorry,
ahead.
in furtherance to the suggestion by my colleague Ish, his point is very clear about point number 2. And the first one I would like to mention that mediation is not a formal process. So what I did recently, that we had a technical issue for one product. I approached to that party that instead we were already into litigation. I said, let us avoid the litigation, and for this technical thing, let us appoint one of the veterans who is having fantastic skills. We approached to the veteran, both the parties decided amicably. We approached, and in 3 days we resolved the issue which was pending since long, for more than 2 years.
Excellent.
So
Yeah,
this
very
way,
clever.
this way it can be adopted. So otherwise, if you write everything here, there, then there is no difference between litigation and a mediation process.
Absolutely.
So this was my point.
Perfect. Yes, the gentleman.
Hi, my name is David. I'm coming from the legal tech aspect of in the law systems. I would like to ask you something. Do you know in the Netherlands or in India or in China, are you using any kinds of ODR systems? For example, maybe arbitration models of technologics or mediator, something like that, of online dispute resolution systems? Because I know, for example, we will take the European Union that they are using, they build a ODR system for all the European Union. So I would like to ask if you are in the Netherlands or in India, because I saw in the internet that the system, the law system, is entering now the ODR system. So I would like to know if you know about it, something like that.
Edith, can I answer that? So, ODR is not really different than ADR. Well, I wouldn't call it ODR because there are a few aspects which you can exclude from the online process. For example, mediation is something where the body language of the parties, the demeanor of the parties, the cultural references, the caucus, meetings that you have, really are not fruitful when you are doing it online. Identical problem with negotiation, but expert determination and arbitration are two things which are already going online. For instance, a lot of arbitrations that I do now and prior to COVID, this was all physical. But with the COVID-19 coming in, it is like a boom for having virtual meetings now. So whether a party is sitting in a different continent or a different city, it's very convenient now to have virtual meetings and virtual hearings of the proceedings. So it's not more of an ODR, but it is actually taking the same process online on virtual meetings. And if you feel, for example, as we're discussing trial, if you feel during cross-examination that you require the physical presence of the witness to notice his demeanor or to to make points or just to make sure that there's no tampering of the witness, you can have physical presence of the witness with the arbitrator. And that's something that I've done that in the past, where the cross-examiner is online but the witness is sitting in my chambers. So this is something that has been regularly being done during this COVID and obviously post now COVID as well.
Yeah, let me add from the Dutch perspective. I was part of online dispute resolution in various proceedings during COVID, because that was actually the factor that speeded up that process. We had 20 proceedings in financial regulatory matters, which also had civil aspects, where the parties were in different countries, where we had hybrid meetings as well as fully online dispute resolution with the courts, with all the problems that were there, actually. The cameras not working, sound not so well, and then these things got better and better. And I also had a online mediation in that part where the parties were in different countries. From my personal expertise, I thought at the beginning, oh, that's wonderful. I don't have to go anywhere. It saves me a lot of time. Let's do that more often. But quite honestly, there is nothing like real face-to-face dispute resolution, mediation, or any other kind of dispute resolution, because body language, the way people behave, things that you cannot see online or that you cannot sense, you will miss that on online dispute resolution. It is an option and a perfect thing that we can have it. All courts in the Netherlands have cameras now that make it possible for the court hearings to be online. And for example, the Netherlands Commercial Court, they are fully ready to do the entire hearing and all the parts of it online, no problem. Also, the rules and regulations are made that this is possible and legally valid. But I do feel, as you know, being a litigator, being there, you feel that something is lacking. And when you're there, it's different. So if you have the option to do it live, I would still do it live. And otherwise, it's a good alternative. And yes, the law has been adapted in the Netherlands to make it possible.
Comment.
Okay. So every technology has pros and cons. But as Edith said so rightly, that human touch needs. And if possible, you can do, if you really want to save the cost, online is better. And cross-examination, COVID has taught us a lot in last 2-3 years. So this we have already started adopting into the litigation also. Still, we have some of the processes online going on. And definitely, if we try to keep trust on each other, and some of the processes like putting affidavit and all, things should go well. So that is what is our suggestions here.
Thank you very much.
Please put your hands together
Thank you.
for the panel. Edith, gentlemen, thank you very much. All right, ladies and gentlemen, we are now going to break for lunch. However, first, just before lunch, there is a group photo with the other conferences in line with ours. And so I will ask you to go to the one floor below, and that is where the photo and the lunch will be. All right, and then we shall reconvene here at 1:30. Thank you.